All right. Well, welcome everybody to the IAPP Web Conference Managing Data Transfers after the EU-U.S. Privacy Shield Invalidation, sponsored today by Aparavi. My name is Dave Cohen. I'm the IAPP's Knowledge Manager, and I'll be your host for today's program. We'll be getting started with the presentation in just a minute, but before we do, I'd like to cover a few program details. Participating in today's web conference will automatically provide IAPP certified privacy professionals who are the named registrants with 1 IAPP CPE credit. Others who are listening in can apply for those credits through an easy-to-use online form on our website. I'd also like to remind you that today's program is being recorded and will be provided free to registered attendees approximately 48 hours following the live event. At that time, the slides will also be available to you in PDF form through a download presentation link just below the recording viewing window. We encourage you to ask questions at any time during the program by typing them into the Q&A field to the right of your PowerPoint window. And your questions will be answered by our panelists either in line or during a designated question and answer just after the presentation. Now on to our program, and I'd like to introduce today's panelists. Debbie Reynolds, the Data Diva, is the founder, CEO, and Chief Data Privacy Officer for Debbie Reynolds Consulting. Debbie, welcome to the panel, and can you tell us a little bit about your consultancy and your professional background? Debbie, you may be on mute if you want to unmute yourself.
Hello, can you hear me?
Yeah, now we can hear you.
Okay, great. I'm Debbie Reynolds, the head of Debbie Reynolds Consulting. I advise Fortune 500 companies and also companies that are working in emerging technologies with data privacy and protection advisory, especially where technology and the legal requirements around the world meet. So I'm well-versed in multinational data flows and data movement, and I'm happy to be here today on the panel.
Fantastic. Thanks, Debbie, and welcome. And joining Debbie on the panel, Beth Winters is an attorney with Solutions Marketing Manager at Aparavi. Beth, welcome to you as well, and can you tell us about your role at Aparavi and also your professional background?
Thanks so much, Dave. My name is Beth Winters. I'm Solution Marketing Manager at Aparavi. I'm also a recovering attorney, and I love combining my legal and business backgrounds to help companies with their unstructured data and compliance challenges.
Wonderful. And Beth, with that, why don't I hand the controls over to you, and you can kick us off and get us started.
Sounds good, Dave. So I just wanted to introduce Aparavi for those of you who are new to us. Aparavi is the data intelligence and automation platform that empowers organizations to truly control and exploit their data simply and without complexity. The Aparavi platform lowers data costs, reduces risk, and produces greater insights for data-driven companies. Intelligent search and advanced automation help users classify, protect, and optimize their data from the edge, on-prem, and across multi-cloud storage, breaking through data silos and transforming operations. For decades, this has required multiple products that are not interoperable and create additional cost and complexity. Aparavi answers today's most demanding data challenges through a simple platform for data governance, compliance, IT consolidation, and open secure access for additional applications in the cloud. And Dave, I want to, at this time, ask the first poll question, if you can bring that up. We'd love to just get a brief survey of the audience to understand which department within your organization you belong to. Thanks so much. And as those are coming in, I will talk a little bit more about the platform. We create a private search engine running in the cloud that helps organizations reduce risk and proactively mitigate the impact of data breaches, discover dark data and high-risk data types like personally identifiable information, confidential documents, or intellectual property. We automate data policies that allow bulk actions on large quantities of data to migrate or defensible, delete, archive, and quarantine information. We also help you demonstrate compliance with smart policies that are automatically updated with new laws and regulatory changes. Audits and reports to demonstrate compliance with regulatory requirements. I'm pleased to be joined today by Debbie Reynolds, the Data Diva. Debbie, and she's going to give us a deep dive into the impact of the EU-U.S. Privacy Shield invalidation and alternative mechanisms for cross-border data transfers. And Debbie, if you want to go ahead and give us the results of the survey.
Sure. So it looks like 53% are in legal in terms of the audience today. 22% are in compliance. We have 5% security, 5% IT, and 16% other. So a decent mix, I would say, of people.
Thanks, Debbie. And I'll turn it over to you to walk us through the deep dive.
Sure. Thank you again. So before we get into the Schrems decision, I think it's important to talk a bit about the history because a lot of what's going on right now, especially what will happen in the future, has a lot to do with what happened in the past up to this point. So as all of us know, the Privacy Shield, the EU-U.S. Privacy Shield, was invalidated in July of this year. There are, between the U.S. and the EU, we have very fundamental differences in how we look at data and data rights. So I like to say in the EU, when we think about privacy rights, privacy is a fundamental human right that is part of the Constitution of the EU and has been for decades. And in the US, privacy rights are mostly around commercial use. So that's why I say the EU has human rights versus consumer rights. So not every human is a consumer. So because the rights that are afforded by the EU, especially as it is codified in data privacy laws, is a bit different than the US laws, which again are more consumer-based or more articulated in sector-specific ways. All right, so there have been quite a few developments that have led up to this invalidation of the Privacy Shield. Before the Privacy Shield, the US and the EU had the Safe Harbor framework that was invalidated in 2015, and the Privacy Shield was a replacement for that. Even though the Privacy Shield was stronger than the Safe Harbor, a lot of the Safe Harbor elements still applied in the Privacy Shield. Like there was still a self-certification scheme. There was certain hoops that companies had to apply to their business, especially as it related to these particular data transfers. And there was a process by which the companies would get certified. So for the Safe Harbor framework, once it was invalidated, only about half of the companies that were part of that first Safe Harbor certification process came aboard to the Privacy Shield. At that point, it sort of splintered off where a lot of companies that did not sign up again for the Privacy Shield went for other things like standard contract clauses, which we'll talk about a little bit later. But some of the tension between the US and the EU related to data sharing, a lot of it has to do with surveillance or indiscriminate data collection of individuals, especially as it relates to grabbing data that may belong to EU citizens that may be wrapped up into law enforcement or any type of surveillance activity related to national security. So probably four of the big major things that happened. There was a FISA section of a Foreign Intelligence Surveillance Act in 2018, which means that a lot of data that's captured as a result of things that are deemed part of Homeland Security or national security in interest, or anything related to terror goes into like a secret court process where there isn't any visibility for the individual, so to speak, in terms of how their data is captured and what happens with that data. Also, due to September 11th, the United States has the Patriot Act, which is second only to the Constitution in the U.S. So in the Constitution, probably the right to privacy that people think about the most is the Fourth Amendment right against unreasonable search and seizure. But under the Patriot Act, if something is deemed, a national security threat or something relates to terrorism, it goes into this other system, which is part of FISA as well. So you don't have the same type of rights in those types of circumstances. In 2013, there were the Edward Snowden revelations about the NSA and their PRISM program in terms of how they were collecting data indiscriminately and being able to search and do different things with individuals' data. And again, that raised some red flags because, again, this data is not just data of people in the U.S., but also data of people in other countries where their rights may not be have been supported in the same way. And then in 2018, and this is one thing that people don't talk about a lot, which is the Cloud Act. So the Cloud Act in 2018 was a way for companies to be able to have the U.S. government have skin in the game. When there's a situation where, let's say, a court order was asking for data of individuals and the data or the individuals are outside of the U.S. So the Cloud Act says that companies can be compelled to turn over information from individuals, even if the data is in another country. The reason why companies were concerned about this is because it will put them in between a rock and a hard place, so to speak. So they will be asked or compelled by a court in the U.S. to give data of someone whose data may be in another country, but they also didn't want to break the privacy laws of those other countries to be able to satisfy these requests. So what the Cloud Act says is, if the company is compelled to get this data over, then the U.S., someone in the executive branch would step in and try to work with that country to make sure they have some type of agreement or understanding in place about this data transfer so that the company who was giving the data wouldn't be held liable under those privacy regulations. So here we go. All right, so the Privacy Shield invalidation, it impacts businesses in the U.S. and worldwide. The Privacy Shield is something that not only the U.S. had, but the Privacy Shield, especially for the U.S., though, was made so that it could be sort of a bridge between the EU laws and the US laws, and if companies that were transferring data could abide by the Privacy Shield tenets that were being managed by the Department of Commerce, companies could use that Privacy Shield as a legal basis for a data transfer. So because the Privacy Shield is no longer valid for EU to US transfers, companies need to find alternative ways to be able to do these data flows. So basically, the Privacy Shield, it was invalidated immediately, which meant that data flows were to stop immediately if a company could not find any alternative legal or lawful data transfer mechanism. Many companies, even before the Privacy Shield was invalidated, have been using standard contract clauses. So for many of the companies that could not use Privacy Shield going forward have been recommended that they use standard contract clauses as an alternative way to be able to transfer data. This has caused a big challenge worldwide, not just in the US, but because standard contract clauses are the most widely used of any transfer mechanism, and the Privacy Shield invalidation basically said that even companies that are using standard contract clauses need to also add additional language into their contracts to make sure that they're using adequate or additional safeguards to make sure that any data transfer that they do is not only lawful, but they're also taking consideration of what country that the data is going to and the country's domestic laws to see if it's incongruent. So instead of a steady flow of data that's being transferred from the EU to the US, this makes those transfers a lot harder, and they have to be assessed on a case-by-case basis. All right.
And Debbie, before you continue for the next slide, can you ask the second poll question? We're curious what. Yeah, we're just curious what legal basis you're currently using to transfer data out of the country.
Yeah, that would be great. It was, well, at first it was 100% standard contract clauses. So I'm sure that would be very high. Well, this is interesting. All right, so it looks like we're almost like 80 or 90%. Was that 77? Almost 80% are using standard contract clauses. About 6% using binding corporate rules. 8% using the Privacy Shield. So, so everyone seems like they're very familiar with standard contract clauses. All right. Excellent.
We have a question. What is it if your company doesn't bother to use a legal basis and just does it anyway? You can write other in the poll.
Right, exactly. I hope that's not the case. I hope that's not the case. I think standard contract clauses, I don't know. I think companies that have been very, very mature in using standard contract clauses have probably already put those additional language in their contracts to make sure that, especially between the data controller and the data processor, it's very clear what the data processor would be doing and how they'd be handling data. So for some companies, again, that were already using standard contract clauses, this probably didn't impact them as much. But I think that because this ruling was meant to sort of shore up standard contract clauses, sort of shook people a bit who weren't probably adding those other dimensions to their contracts. And then, of course, for the 5,000 plus companies that have been using the Privacy Shield, they obviously have been trying to find alternative means of data transfer, if at all. All right, so the legal basis for transfers, and actually this is an important point. So the Privacy Shield went into effect before the GDPR went into effect. So in essence, part of this ruling about the Privacy Shield was really connecting some of the mechanisms that were previously using the Privacy Shield to the GDPR. So under the GDPR, there are several legal bases for transfer or mechanisms for transfer that could be used. One is adequacy, right? So any country that's outside of the EU will be considered a third country, but third countries could be adequate or inadequate. So because of the Privacy Shield invalidation, the U.S. can no longer use Privacy Shield and became an inadequate country as of this year. Also, again, standard contract clauses, as long as can be used, as long as they're subject to appropriate safeguards to make sure that, again, not just plugging and play with the standard contract clauses that are used, but also making sure there's more meat on those contracts, and that is being assessed on a case-by-case basis. Binding corporate rules. So very few companies, not enough companies, use binding corporate rules, and binding corporate rules, they have to be approved by the EU. They take quite a long time to get approved, so this would not be a good short-term solution for a company. So for example, if a company was using only the Privacy Shield to transfer data from the EU to the US, they wouldn't be able to immediately use binding corporate rules. That's more of a long-term thing, and also binding corporate rules are related to data transfers within companies, so that wouldn't impact a situation where a company will say using a third-party vendor or sending data outside of a company. Derogations. Derogations are used quite a bit. They're supposed to be used for special circumstances. I've seen them used in situations where, let's say, there was a vendor or a company that has some type of special thing that only they could do, where it made sense to be able to transfer this data from the EU to the US. And derogations, again, somewhat like standard contract clauses, but you're writing into contracts, making very clear what the controller's role is, what the processor role is, and not in a generic sense. So thinking of it on a case-by-case basis, thinking of all the things that need to happen in your particular project, and making sure that the derogation for specific situations can be applied. Derogations probably aren't a good way to go if this is a repetitive type of transfer that happens on a regular basis, but there are situations where derogations make sense to use. And then approved codes of conduct. So companies or associations can create codes of conduct that have to be approved by the EU to make sure that it aligns with the GDPR, and that the companies who are following it make sure that they have like an audit process in place, and they're very, very specific with how they're using their data. So that's something I think is going to be used a lot more in the future, as I see other companies or organizations try to create codes of conduct that people can use for their legal basis of data transfer.
And Debbie, we have a couple of questions about standard contract clauses. Do you want to take them now, or do you want to take them later?
Someone can read them for me. So I can barely see that.
Sure. Although the use of extended standard contract clauses is recommended, how do you tackle that with the possible interference from the U.S. government, even in that situation?
Well, this is such a tough situation. So the issue is that if the government should ask a U.S. company to turn over data, they do have some level of redress or pushback that they can do within these FISA courts, but it's very limited. It doesn't, if data is transferred to the U.S. from the EU, even using standard contract clauses, those things don't supersede national security law. So it really is a balancing act where the company has to really evaluate, is this data that I'm sending, would it be of interest, to law enforcement? Is this something that's a low risk for the company if they decide to transfer it over? Anyway, there is something that is actually part of the Cloud Act, which says that if a company is compelled to send data or transfer data over to the government for whatever law enforcement purpose they use it for, the company itself is not compelled to break encryption that was given to it by the customer. So let's say you had an encrypted file on a cloud server somewhere in the U.S. that you encrypted yourself, and the company was compelled to turn over your data and other data of other people. If those files were encrypted by you, the company would not need to decrypt that. That would be something that either law enforcement would do, or maybe they would try to find some other alternative. So I've heard that being used in the past, even though that's a very thin way to be able to protect that data. But you really just have to think about what you're sending and whether you think it will be a risk for the individual. Did you have another question?
Right. And that's why, yeah, so that, I mean, I assume that's why it has to be decided on a case-by-case basis. But we also have a comment that authorities in the EU are basically working on some advice about standard contract clauses, and in the meantime, they've been told not to use them, especially in the case of health data, to stop data flow immediately. Do you have any thoughts about what the EU is working on, and what their opinion might be?
Good question. I would highly recommend that people reevaluate, just as the EU is doing, what types of data gets sent over. So I would say special category data, like health data, those are things you should probably think twice about sending if you're really concerned about this issue. Maybe it's not as much of an issue. Let's say if this, usernames or some other services that aren't kind of high risk in terms of a personal data situation. I would definitely reconsider that.
Mm-hmm. Yeah. And then, I mean, I guess you could also use derogations if there's a pressing issue. You can ask and
yeah.
See what they think.
Derogations really it's just sort of like the catch-all for things. It doesn't fit in other categories. But again, that none of these things that we're talking about supersedes kind of the national security law, if it should come to that. And even though it is a slight possibility, it's still a possibility. So that's the reason why people are concerned about these data transfers.
Right. Okay. And then there's one more. This is a more specific question from Nick Richards. In the UK, he has a client who's a processor and has over 1,000 customers, mainly tiny businesses who are the controllers. Their client uses a sub-processor in the US to process sensitive special category data. How can that client possibly set up standard contract clauses and organize safeguards, risk assessments, et cetera, when the customers, the controllers, have no relationship with the US sub-processors?
Okay, that's more of a complicated question. Why don't we have that one? I can definitely answer that question, but I probably want to do it offline. Who is this, Nick?
Sounds good.
Yeah.
Yes,
Nick. So I'll be
Richards.
happy.
Yeah.
Okay, Nick. I'll be happy to answer that. That one takes a bit more noodling to be able to answer. But yeah, these are all tricky things because, I know a lot of companies, they are, it creates a lot of problems when you're working with third parties, but every company works with third parties. So this is not a situation where you can just not work with third parties. So this is an issue that every company would have to broach at some point or another. Okay. Definitely. So the EU Commission over the years has granted adequacy decisions to certain countries. Adequacy is reevaluated every 4 years. Some main countries people think about that have adequacy. A lot of people think about Canada since it's close to the U.S., even though they only have adequacy for commercial organizations. New Zealand, Switzerland, Israel, Uruguay, New Jersey. Japan was just added last year, actually. And so, as you see, the U.S. is on this list as of July of this year. And currently, the United Kingdom is seeking possible adequacy after Brexit. So this is a huge question that people are asking. I think it's put a spotlight right now on the United Kingdom, especially after the Privacy Shield was invalidated. So the UK has its own GDPR regulation, which is almost a carbon copy of the European, the EU GDPR, but it has different provisions in it, like things for immigration, national security, or intelligence gathering. So, everyone's really waiting to see, because Brexit, the transition period ends at the end of December this year. So I'm hoping that they get adequacy. If not, it'll be, you can transfer data from the United Kingdom to the EU, because the United Kingdom gave the European Union adequacy. So we're waiting to see if that will be reciprocated the other way.
I think that answers Gilbert's question. Will the UK, in case of no deal with Brexit, come into the same situation as the US and EU have right now?
That's right. Yes, that's exactly what's going to happen. So it would be considered an inadequate third country if there is no deal around the data privacy laws related to Brexit. So I'm hoping that doesn't happen, but it's very late at this stage, so people are very nervous about that. All right. Probably one interesting thing, though, I will add is that the United Kingdom, because they have their own GDPR, and they can, I guess after Brexit, they can decide what they want to do with the U.S., that the Privacy Shield would possibly stand, I believe, in the UK and not in the EU still. So that's a new wrinkle in that whole situation. All right. Impact of standard contract clauses. Standard contract clauses are the most popular method for transferring data to a third country. We're seeing from our poll that we did that almost 80%, and I think that's the figure worldwide, almost 80% of companies use standard contract clauses as their data transfer mechanisms. Again, standard contract clauses, they're part of a contract. You can't change those clauses, but you can add additional meat to your contract to be able to make sure that you have a strong agreement amongst the controllers and the processors about how data will be handled on a case-by-case or project-by-project basis, right? So again, more clauses are needed. So just putting a standard contract clause in a contract is probably not sufficient. You really need to get down to the nuts and bolts of what each party is going to be doing and how they're going to be able to protect the data. All right. Controllers, if they can't get the adequate protections they feel comfortable with, they are to stop data transfers to processors. So a lot of this Privacy Shield invalidation puts a lot of pressure on controllers to be able to make those decisions, because even though the data processors have responsibility as a party to these contracts, it really is the controller that needs to be able to make these decisions and be the decider about what should happen with these contracts based on what they feel is right and what they're asking the processor to do.
And in most cases, does that speak to whether they have recourse? Is that really one of the primary considerations there?
Well, recourse should be a consideration. So in the Privacy Shield invalidation, they said that companies need to consider the national laws of the country as well, as well as the contract terms. So this is such a new area. So when you think about doing contract, you're typically thinking about the parties to the contract. You're not necessarily thinking about the national laws of a country. So that definitely has to be a consideration that the controller has to think about. Does that answer your question?
Yep. Okay,
great. So this evaluation needs to happen on a case-by-case basis. As I said, the thing that the Privacy Shield had given was more, if a company could say that they comply with, these high-level categories, they didn't have to do this case-by-case evaluation. But now, without the Privacy Shield, it makes it much tougher, and you do have to do a case-by-case evaluation to decide whether the country has adequate protections. And then, again, about the national laws, the recourse is different. The recourse really is a challenging concept. So recourse is one of the main reasons why the safe harbor framework was invalidated. And in the Privacy Shield, they came up with a scheme where they had an ombudsman within the Department of Commerce, and if an EU person had a complaint, they could have sort of like a mini court hearing of some sort, which would provide EU people with redress. The problem with redress is that, when people think about it, and the EU, sometimes they're thinking what they're asking for is that the EU citizen be extended redress in normal courts like we have in the U.S. But the thing that they have to remember is that the U.S. does not have redress for U.S. individuals for privacy violations like something that would happen with the Privacy Shield. So that's a sticking point, and I don't know how that's going to get resolved, because it's been an issue for many years, and it obviously that's not going to be resolved probably in the way that people think it will be. So I don't know if there's going to be a new court created for this, or whether they're just going to go through our regular kind of common law system to try to figure out what's the best way to get redress for individuals. But I would imagine that would make people in the U.S. say, wait a minute, why can't I have redress for these things? So, all right. So options for data transfers. Oh.
Yep. Before you continue, I'd love to ask the third poll question. And that's what are you doing differently as a result of the EU-U.S. Privacy Shield invalidation?
Okay. This would be interesting.
Yep. And so we're waiting for those results to come in. It looks like the majority are saying they're not doing anything differently. About 70%. To go to the companies who have the standard contract clauses, hopefully, and or they have binding contracts.
Yeah. So a small amount say they're transferring data to other countries, 33%. I would imagine if, let's say, for instance, a company, because the invalidation happened so recently, I doubt a ton of companies have transitioned so far to transferring data to non-U.S. companies. Collecting that less data, that's a really great idea to do. It's about 7%. Keeping data in country, that's 16%, and then not doing anything differently. And that's really what I'm hearing from a lot of people. I think some companies are waiting either for more guidance or, it really, especially because there was no transition period with the Privacy Shield invalidation. A lot of companies, because of the work that they were doing, couldn't technically stop what they were doing. Maybe some are sort of pausing on starting new things, but things are in progress. A lot of companies aren't starting. And again, like you said, some companies had already been using standard contract clauses. So this may not have been a huge change for them.
Right. And I mean, the standard contract clauses, that number was about 80%. That's very close to the 75% number.
It is, absolutely. So hooray for people who are using standard contract clauses. I recommended after the safe harbor was invalidated totally that people went that direction for this purpose. So, all right. All right, excellent. That's a good poll. All right, so let me go back. So options for data transfers after the EU-U.S. Privacy Shield invalidation. The most obvious one is to repatriate the data to the EU or not ever send it out of the EU. We're seeing a lot of economic push in the EU, and this has been happening for several years actually, to try to get more businesses to do like cloud services or other types of services that would have typically gone to U.S. companies, to try to do some of that within the EU and not actually move data. So, or if data is in the U.S. or with a U.S. company, move it to a U.S. service provider, especially so that it'll be out of reach of things like companies that have to comply with court orders about giving data to U.S. courts as a result of the Cloud Act. All right, data transfers to countries with adequate protection. So we saw in the poll that not a ton of people have done that, but I think it's been so soon. I don't see a lot of companies pivoting that way since it's been such a short amount of time. But that's definitely a option that people can think about, transferring data to countries with adequate protection. Again, we don't know yet whether the United Kingdom will get adequacy from the EU, but there are other countries that are probably trying to get adequacy as well. Probably India, maybe one of them, I believe. So it just remains to be seen how this is going to happen. And I think that a lot of other countries, as a result of this invalidation, will seek adequacy decisions from the EU. All right. Minimize data to be transferred. So this goes back to maybe that conversation that we were talking about before about some companies don't want to transfer health data. That I would highly recommend that. And definitely just to reevaluate the type of data that's being sent out to any third country, and then minimize or reduce or eliminate the transfer of personally identifiable data. So again, I think data should have, maybe you should grade your data as high, medium, low risk data if you can. And if you have to send certain data to a third country that has inadequate protection, I would say basically try not to send any of those high risk categories of data outside of the country.
And we have another question. What is the legal situation regarding FISA for U.S. companies who use data centers in the EU or maybe set up subsidiaries in the EU? Can the U.S. still get access to that data?
As far as I understand from the reading of it, the answer is yes. So, and this is a problem that's crept up because the Privacy Shield was enacted in 2016 and it was invalidated in 2020. And then the Cloud Act went into effect in 2018. So this creates like another challenge that we had not anticipated at the time that the Privacy Shield was enacted. So unless there's something that changes in that law or changes between an agreement with the U.S. and the EU, the answer is yes. So even if a company has subsidiaries in other countries, because they're U.S. based, they may be asked to be able to give that data over.
And there's another similar question. Can you reflect on the issue of big processing companies like Amazon who have data centers in Ireland and Frankfurt, Germany? Is data safe with AWS in the EU? A lot of companies doubt that, right?
Well, they do, but also there are other legal bases to transfer data. So the Privacy Shield was just one, like performance of a contract and consent. So let's say I'm an individual and I have a cloud account with Google or whatever. My consent may, depending on where I live or what country I'm in the EU, may be sufficient for the type of data storage and data transfer that's actually being able to happen. But there's so many different categories of data and so many different reasons why data is transferred, that it may get a little bit sticky. So I think if you have not seen already, some companies may have tried to send you a notice about maybe the privacy shield and maybe asking you to consent, give your explicit consent to continue using your data. So it's kind of a tricky thing, especially, I don't think it has as much, I don't think it's as risky as an individual. If you're, like, say, you're a customer of Amazon or a customer of Google, because if you decide to consent, then that is a legal basis for transfer. But if there's like mass data being transferred for other purposes where there isn't like a clear legal basis, and if that data is sensitive in nature, that may be of a concern. Does that answer the question, do you think? Can you hear me, Beth?
Yes, sorry, that answers the question. Thanks.
Okay. I don't know if you guys seen it in the news, but Facebook specifically is really working with the EU on this situation, because apparently they used or have used the privacy shield pretty heavily. But what I've seen is a lot of big companies like that, they use as many legal bases as possible. So they'll probably have situations where almost any and all legal bases that could possibly be used are being used for different categories of data. So, all right. Right on this topic, alternative legal basis for transfer. One is performance of a contract. Like I said, the consent of the individual in certain countries, maybe countries like France that may not work as well, because France in some situations have blocking statutes, and that still is something to be considered. Also, Germany was saying to controllers that they wanted controllers, if they were transferring data to the U.S., to stop immediately. So it's sort of a little different country to country, but the general guidance is if you can't find another legal basis or another way to transfer the data where you feel it is safe, the controller should not do that. So legal claims is one, derogations is one. I highly recommend people look into derogations because it may fit for your particular business, especially if it's not a transfer that happens constantly. So, yeah, that's it.
And then there's a question that is specific to explicit consent as a derogation, because to make it valid, they would need to point out all the potential risks, including the possibility of government interference. Do you think they do that?
If they don't, they should do that. So I've used derogations before in other situations, and I think that should be clearly stated in the contract, so that both the controller and the processor know, that this, it may be, even if it's a faint possibility, it should be noted that it is a possibility. Absolutely.
Right. Thanks.
Yeah. That was a good question, by the way. So update contracts, that goes right into our next thing. So if that's not in, let's say if you're using derogations, if that's not in your contract, you need to put it in there about kind of the national laws and stuff like that. So you definitely want to update these contracts with any additional safeguards. Often if you're working with a third party, you have to map out what the controller's role is going to be, in particular, what the processor or multiple processors are going to be doing, to make sure that you cover all the things that are under the GDPR in terms of what every role needs to be able to do within a contract. And then any additional safeguards that you need to add need to be put into those contracts as well. So whether that be something about how you're going to store the data, how you're going to manage the data, how you're going to report back to like the processor, how they're going to report up to a controller about any issues that happen. All that stuff should be really spelled out in those contracts.
And we have another question for EU personal data. If the controller is in the US and wants to transfer to an EU processor, there's not an issue with that transfer, but how does the subsequent transfer of data back to the US occur if there's no processor to controller standard contractual clause?
Well, right. So like you said, the US, the EU, that's not a problem. The EU to the US, as long as you can find another legal basis for that transfer and it's all, everyone is clear on what their role should be and you understand the risk, having a contract with a standard contract clause or using a derogation may work for you to be able to do that transfer. But a lot of that depends on the controller and what they feel comfortable with in terms of risk. Does that answer your question?
Yes, and one more question, that you need to provide the information related to processing the data subject in a concise, transparent, intelligible, and easily accessible form using clear and plain language. Do you see that being done, or is there kind of an issue with?
I think there's a lot of work that has to be done on that regard. Even you think about terms and conditions statements. You download an app or something, it's like 80 pages. That's ridiculous. So I think being able to make it extremely clear, especially if you're trying to get consent of an individual, it needs to be extremely clear, very concise, what you're doing with your data. And I think I would like to see more clarity in that regard and not a ton of pages of things that people have to look through. I think 80 pages or 50 pages of any consents or terms and conditions may be like way overboard. So it should be clear and concise. And also if you're using the consent of the individual, and this is one of the reasons why companies don't like to do it, is that under the GDPR, people can revoke consent. So consent is more fragile and it is granular. So people can consent to some things and not others. So it becomes a lot more of a challenge in terms of a company being able to manage that part of consent. So obviously companies want people to consent, but it's harder to get to revoke consent and be able to provide the transparency that they would need in that situation.
Right.
Yeah. Anonymized or pseudonymized data. So this is definitely something that people should think about doing. It is easier said than done to anonymize or pseudonymize data. It can be time consuming. It can be laborious. It's obviously you probably, especially if you're doing on some mass scale, you need some type of software to be able to do this type of thing. It also takes a lot of planning and thought before you start down this road, but this is an option that companies need to be thinking about, because if you anonymize the data or pseudonymize the data sufficiently, then you aren't going to run afoul of the Privacy Shield or the GDPR or anything like that. So almost all privacy laws, even in other countries, have some type of exception if data is anonymized or pseudonymized in some way, shape, or form. So I would say remove personally identifiable information from data sets if you can, and then that doesn't, that's something that's an acceptable way to transfer data or to share data across borders without running afoul of these privacy regulations.
Yeah, great. And we're going to talk about a little bit how Aparavi can help with that.
Yeah, definitely. Yeah, I don't know. People people say it so flippantly about anonymization. It's not easy. It's definitely not an easy thing to do. Consider binding corporate rules. So I would recommend that people consider binding corporate rules. If you do a lot of internal, you have a big company, multinational company, you do these data transfers internally, and you think you're going to be doing them for a long time. It doesn't replace, like if you need to do a transfer today, binding corporate rules are not going to help you. But if you want to do it, you plan to do it for several years down the line, it may make sense to invest the time and the effort into trying to get acceptable binding corporate rules in place with the EU. And again, it takes a while to get these approved and to have them working. So I think pretty sure many of the big companies, almost all of the really big ones, use binding corporate rules in addition to other ways that they transfer data.
Right, and I just saw IAPP put out an article about the list of companies that do use binding corporate rules. So that was interesting to check out if you haven't seen it. Yeah,
it's not a big list. It's not a long list. So yeah. Okay, and encryption. So encryption is controversial, especially when you talk about additional safeguards, because in theory, if you're transferring data anywhere, you should be trying to protect it in some way, and encryption is one of those ways that you should be protecting it. Some feel it should be considered as additional safeguards, but again, this is something even before the Privacy Shield invalidation. I think that people assumed that companies were taking additional safeguards in terms of the security of the data. What encryption doesn't do is it doesn't protect the rights of the individual. So just because something is encrypted, it can be decrypted at times. So this is not like I don't think this is a good way to protect the rights of the individual. Encryption may protect the data that belongs to the individual from a security standpoint, but not as a way to protect a human right, I don't think. So I definitely agree that encryption should be used as an extra layer of data security with the data transfer, but there's no guarantee against U.S. government data requests, even if encryption is used. But again, I said there are a couple of countries around the world that are really pushing to get companies to break their own encryption or create some type of vulnerability for law enforcement to be able to look at certain things. And this is going on all over the world, actually, especially with the Five Eyes countries. That's the U.S., United Kingdom, New Zealand, Australia, and Canada. So there's definitely a push for that, but that does not cover things that are encrypted by the individual. Because if I encrypt something and put it in the cloud, for example, and it's turned over to law enforcement, the company is not obligated to decrypt something that I encrypted personally. So this is going to be a hot issue that people are going to talk about a lot. But I think anything that you can do to protect your data in terms of security of it, in terms of cybersecurity, is very important. And again, it doesn't really apply to data privacy in terms of protecting the human right of an individual. So that's my opinion.
Right, and it sounds like required anyway under the GDPR that you do everything possible to secure the data. So encryption makes a lot of sense from that point of view.
Yeah, and then that's a little bit controversial too, because some people, the GDPR doesn't exactly say encryption. They say you should protect the data, but I think it's good they put it that way because there are multiple ways to protect data, and maybe someone comes up with something that's better than encryption. Who knows?
Is tokenization a good measure to protect data?
Yeah, tokenization is a great method. People don't talk about it a lot, but yeah, tokenization basically makes the data useless to anyone who doesn't have the appropriate level of access to look at the data. So yeah, anything that can protect data is an excellent safeguard. in terms of cybersecurity.
Definitely. And the way Aparavi can help with all of this, we help organizations unlock the value of their data while reducing risk, costs, and complexity. So we're able to give you some really detailed metrics about your data, as well as drill down into different types of personally identifiable information so you can take bulk action on that PII. And we are able to then reduce cost and complexity, reduce data risk, reduce data storage by reducing your data footprint, reduce legal collections time and response to information requests like CFAR, and increase automation for governance and compliance. Some of our best features are defined classification policies. So we have 140 defined classification policies, including all of those country-specific regulations, CCPA, LGBTQ, civilian privacy law, PCI, DSS, SOX, GLBA, and many more. But you can also create your own classification policies. And Debbie, I think I hear you typing in the background. You can mute yourself.
I'm sorry, did you say I need to mute myself?
Yeah, I hear you typing back there.
No, I was on mute. I don't know if that's someone else.
All right, sorry about that. Well, and then we also have a lot of options for different companies. We have a starter pack where you can classify 5 million files or 5 terabytes of data with one classification policy for free. And you can explore that on the Microsoft Azure Marketplace, but we also, you can also reach out to us directly, info@aparavi.com, or you can reach out to me with any questions, or if you want to get started, beth.winters@aparavi.com. And obviously these prices are a lot less when you have those fines you might be subject to under GDPR or CCPA and other regulations. And thank you, Debbie, for taking the time to talk to us about this interesting topic. Does anybody else have any questions at this time? Please feel free to type them into the question box or into the chat box.
Yeah,
I see one.
Dave coming back on the line. Hello?
Hi,
This is Dave coming back online. Thanks very much, Beth, and thanks, Debbie. Unfortunately, we're out of time. We're just a few minutes actually over the hour. So we don't have any more time for questions. I'm glad we got a chance to take so many in line. That was terrific. Thank you, Debbie, for all of your great insight and advice, and thank you, Beth, for your excellent moderation of all of that. That was fantastic. If you do have further questions for either Beth or Debbie or myself for that matter, the slide in front of you, if you're listening to this live, has live links to queue up an email and shoot that off to us, and we'll do our best to get back to you. So thank you both for being panelists today. And a big thank you to Aparavi for sponsoring the web conference today. It's available to all of you out there in the IAPP membership and beyond. We really appreciate your support, Aparavi. It's really fantastic. And thanks to all of you in the audience for dialing in today and listening. I hope you got some really practical information and insights to take back and put into play at your organization. And on that note, if you can please take just literally 2 minutes of your time. If you're listening to this program live, that link in front of you takes you to a very quick survey. It's just 2 minutes, and you can give us some feedback about what you thought of this program. And also you can let us know what topics you'd like to hear about on future programs. There's a field in there where you can let us know what issues you're struggling with, and perhaps we can put together a privacy education webinar on that topic. As I mentioned at the beginning of the program, if you're an IATP certified privacy professional and you have your certification with us, you can, and if you register to our website, you will automatically be granted 1 CPE credit, so you can, you don't have to worry about anything. We'll just take care of that for you. And if you're not certified, if you didn't register to the website, you can still apply for that credit by going to the IAPP website and clicking on the certification tab. And with that, thank you all one last time for joining us, and I'll take us to a program close.